Happy New Day. Happy New Day, everybody. There's something that is disturbing me. This disturbed me the entire night. Wishing away a certain law that exists and it empowers South Africans to assist the police. Section 42 of the Criminal Procedure Act, 51 of 1977, exists. You can't wish it away. You can't threaten it. Y'all created a situation in South Africa. Your government created a situation in South Africa together with the authorities that you are sending us to. And you know what these authorities do whenever they have to do their work? They don't want to do it. You know why they don't want to do it? Because they are in the pockets. So, South African government has two problems. The first problem, when they discover there's an issue, they don't address it. They dilly-dally around it until South Africans start showing up. And then suddenly there's 600 million rand to stop South Africans from exercising their constitutional rights like protesting peacefully. The second thing, South African government loses narratives within and international. They don't come immediately and clean it out. You would swear that we don't have the Department of Communication. What's that minister doing? Because I believe he is also a spin doctor of the country. South Africans, whom, by the way, are empowered by the constitution of this country. I'm talking about Section 42 is empowered by the constitution of South Africa. And then you have a minister that decided, okay, put your heads together, you staff members, and I need to say something to South Africans about this Section 42. And this is the best they came with, a threat of impersonating a police officer. So I thought, okay, wait, maybe the minister is right. But in order for me to understand if the minister is right, I need to go down the rabbit hole. And I need to research Section 42. So that whenever I speak about Section 42 to my community, the clan, it is informed. And if the minister is right or wrong. So here goes my little research. So I'm going to be reading, and I hope you will still be able to see me. So my research was understanding Section 42, citizens' arrests, the Criminal Procedure Act 51 of 1977, and its constitutional basis, because it was important for me to understand the constitutional basis of Section 42, because we live in a constitutional democracy. Everything about our dispensation, it boils down to the Constitution and the supremacy of the Constitution. That means only the Constitution has the power and the final arbiter for anything that goes on in South Africa. All right? So, Section 42 of the Criminal Procedure Act 51 of 1977 is one of the legal provisions that regulates the power of private persons, commonly referred to as ordinary citizens, to arrest individuals under limited circumstances. I think South Africans understand that very well, that we know we are not police officers, but we want to assist the police officers. And in order for us to capture a criminal, remember, an illegal foreigner is a criminal. We might not ask for their papers, but because they live in our communities, they are the ones that talk a different language that we don't speak. We know that they are illegal foreigners. We know that we are not police officers. And I agree that no ordinary citizen, even under Section 42, should ask anybody for their documentation. I agree with the minister there. But taking away Section 42 and pretend as if it doesn't exist, That's the problem I'm having. It's there, Minister. You know, the law is the law. It might be a pain under your foot, but it exists. This provision forms part of South Africa's criminal justice framework and exists to assist in the prevention of crime where law enforcement officers are not immediately available. Oh, yeah, we don't have a van. We don't have this, and we do have, or we are available to make that arrest and wait for the van. We know that. Oh, okay, let's continue. However, because an arrest limits a person's freedom, Section 42 must always be interpreted together with the Constitution of the Republic of South Africa, Act 108 of 1996, which guarantees fundamental human rights. So far, I agree, Minister. I agree that whenever you are going to do these things, there are all kinds of provisions of the Constitution that must be followed by the private citizen that is conducting the arrest. I understand that Section 35 must be one of those that are considered. So that means it is your responsibility as the Minister of Justice and Constitutional Development. First of all, Minister, why haven't you distributed copies of the Constitution to the people of South Africa? Do you understand that most of these misunderstandings is because you are withholding a fundamental book, supreme guiding document that every South African must have and understand, so that times like this, we can always refer to the Constitution and yourself. So I want to know, when are you going to distribute copies of the Constitution? Because you are doing South Africans dirty by not distributing. And South Africans do have that right, by the way. We don't have to go to CNA and exclusive books and spend hundreds of rands to get a copy. It is your responsibility so that you do not do outbursts. You are making outbursts on something that you're supposed to have remedied. Maybe not you, your predecessors and whoever is coming next. The Constitution should be distributed at least every 5 years. I'm talking about a copy, Minister. Every household, an individual in that household must have the Constitution. Let's continue. This is now what we have to do. So we have to understand what is citizen's arrest. A citizen's arrest is an arrest carried out by a person who is not a police officer or peace officer. It allows members of the public to intervene in exceptional circumstances when they witness criminal conduct. Illegal foreigners, there are criminal conduct everywhere. Nigerians, do you know that we can actually do citizen's arrest of Nigerians? Kolane Kumalo is doing. He's following exactly what Section 42 is saying to the T. It allows members of the public to intervene in exceptional circumstances when they witness criminal conduct or when the law specifically authorizes them to act. The purpose of Section 42 is not to encourage vigilantism, and I agree, or private policing, and I agree. Instead, it provides a lawful mechanism for temporarily detaining a suspected offender until the individual can be handed over to the South African Police Service. I agree 100% with that. Now, we also need to understand what I, as a private citizen who is witnessing a crime, and I know that the police, it will take at least an hour to get here, or sometimes even 12 hours, and I can stop the crime that is happening in front of me. Now, I need to understand, what are my limits? What am I allowed to do? What am I not allowed to do? But I'm going to tell the minister that South Africans know exactly what they are allowed to do, what they are not allowed to do. Anyways, let's go ahead. Section 42 generally authorizes a private person to arrest another person in limited situations described or prescribed by the law. These include circumstances where, bullet point number 1, a person commits or attempts to commit an offense in the presence of the person making the arrest. Bullet point number 2, the offense is one that justifies arrest without a warrant under South African law. And 3, the arresting citizens acts on reasonable grounds and within the limits prescribed by the Criminal Procedure Act. I believe South Africans understand that 100%. Where are we impersonating? Unlike police officers, ordinary citizens do not possess broad investigative or arrest powers. Their authority exists only in narrowly defined situations. After making such an arrest, the citizen must hand the arrested person over to the police as soon as reasonably possible. Keeping the person detained unnecessarily may amount to unlawful detention. I agree with that. And this is where we are having trouble with our police officers, minister. South Africans are making these citizens arrest on criminals, crimes that are happening right in front of them. And then because when they call 10-111, nobody is answering, they call 112, you get put on hold, and then this music play in the background. And this side, time is moving because you just detained a criminal. Now, it does not necessarily tell us what is the time frame, but I know that if you go to Section 35 of the Constitution, you cannot detain a suspect more than 48 hours. That's what the Constitution says. So that means reasonable time, or as soon as possibly, as soon as reasonably possible, could be between the time you arrest the suspect and 48 hours later, because you will still be within the bounds of the law. I don't know. This is where the minister's job comes in, to educate us. So there are requirements for citizens' arrest that we must understand. Again, South Africans know this. But again, we just want to let the minister know that we know you are wrong when you are taking Section 42 and label it as impersonation of police officers. So far as we are reading, it's not directing us towards that accusation. And I foresee court cases, in fact, lawsuits against the Minister of Justice and Constitutional Development, if indeed he arrests South Africans who are exercising this constitutional regulation. Yeah, it is a constitutional regulation. So the requirements for lawful citizens' arrest. For a citizen's arrest to be lawful, several requirements should generally be satisfied. 1, there must be lawful authority. Yeah, Section 42 is the lawful authority. The arrest must fall within the circumstances authorized by Section 42. Yep, just like I said. A person cannot simply arrest another because they believe someone has behaved suspiciously. 2, reasonable grounds. The arresting citizen must have reasonable grounds for believing that the legal requirements for arrest exist. Mere suspicion, prejudice, or rumor is insufficient. 3, immediate handover to South African Police Service. Once the suspect has been restrained, the arresting citizen should contact the police without unnecessary delay. I agree with that. The purpose is to transfer custody to lawful authorities rather than conduct a private investigation or punishment. I do not agree that once a private citizen has made a citizen's arrest, now suddenly you are an investigator, like you are checking people's documentation. I don't support that. I really don't support that. If you suspect that this individual is an illegal foreigner, call the police or call Home Affairs or immigration, whatever the case is. Let them do that part. You let them do that part. Not you. You keep the person and you make a call. You don't punish them either. Please, no punishing of people. 4, reasonable force only. If force becomes necessary, only the minimum force reasonably required under the circumstances may be used. Excessive violence can expose the arresting citizen to criminal prosecution or civil liability. Listen, if the suspect is acting all sorts of ways, you need to learn how to subdue them without hurting them, because the moment you hurt them, you are now a criminal yourself. So minimum force, use minimum force. Do not beat a person and hurt them and break them. No, you are now a criminal. You're no longer a citizen that was doing country duty type of situation. Now, this was what I was most interested in, because at the end of the day, we cannot have ministers going around threatening citizens simply because they're wishing Section 42 away. Ma'am, Section 42 of the Criminal Procedure Act exists. It's the law. You can't wish it away. So my biggest interest was the constitutional regulation of citizens' arrests. It was important to understand where in the Constitution that allows this. Although Section 42 provides statutory authority, it operates under the supremacy of the Constitution. Several constitutional provisions regulate how citizens' arrest must be exercised. Section 1, subsection C, in the rule of law, which is in the Constitution. Section 1C establishes the supremacy of the Constitution and the rule of law. This means every exercise of public or private legal power, including citizens' arrest, must comply with constitutional principles. I fully agree with that. Now, these are important for citizens of this country to understand that the Constitution is not 100% on your side when you are going to do citizens' arrests. You need to make considerations. Otherwise, you would think you're doing the right thing only to turn out you now the criminal. Now, according to the Constitution, Section 10 of the Constitution, we all know that's human dignity. So meaning the person that you are going to do citizens arrest on, you need to consider their human dignity. So you can't come now because you suspected somebody from Shangimvub. It's wrong. You are being violent. And you are now a criminal. I cannot support you. I cannot support you anymore, because you are now a criminal. So human dignity it must be exercised when you are doing citizens arrest. Every person has the right to have their dignity respected and protected. Even suspected criminals retains constitutional rights during an arrest. Section 12, freedom and security of the person. Perhaps the most important constitutional provision is Section 12, which provides that everyone has the right, 1, not to be deprived of freedom arbitrarily or without a just cause, 2, to be free from all forms of violence, and 3, not to be treated or punished in a cruel, inhumane, or degrading manner. So, citizens, when you are doing a citizen's arrest, please treat people like people. Like how you would want to be treated. A human being. All right? So I agree with that. Freedom is one of the most important constitutional or fundamental constitutional right in this country. That is why we have bail, because of Section 12 of the Constitution. Because an arrest temporarily deprives someone of liberty, Section 42 must always be interpreted consistently with Section 12. So when Section 12 of the Constitution must work with Section 42 of the Criminal Procedure Act. I will remind you again what Section 12 says when you are doing this. Do not deprive a person of their freedom arbitrarily. Just because you are empowered by Section 42 of the Criminal Procedure Act does not give you power now to walk on it towards anybody. Which, yeah, when you are, hey. No. You also need to behave with dignity. Awuthande nawe when you are doing this. You must respect people's freedoms. You must not be violent towards them. And also, you do not treat them with any sort of punishment or cruelty. Those are the ones that deserve jail. Honestly speaking, those are the ones that deserve jail. And then, of course, Section 35, rights of arrested persons. As I've said earlier, once arrested, every individual enjoys constitutional protections under Section 35, including the right to remain silent. So the person that you might be arresting, they have a right to remain silent. So you cannot force them to answer your questions. For example, they say, do you want their papers? They have a right to refuse. And you must remember Section 12. The moment you are feeling a little bit angry and emotional, no, calm down. You will get yourself into trouble. So they have a right to remain silent. They also to be informed of the reason for the arrest. You have to inform them, why are you arresting them? 3, consult a legal practitioner. So if they say, can I call my lawyer? You cannot say no. You cannot say no to them. You allow them to make a call to their lawyer, whether the lawyer comes where they are detained by you or at the police station when they are handed over. 4, be brought before court within constitutionally prescribed period. That's 48 hours, according to Section 35. And then, of course, why does Constitution permit citizens' arrest? That's very important to understand. The Constitution recognizes that maintaining public safety is important. Very important to us. We have a right in our communities to clean what is a threat to us. There are situations where police officers cannot immediately respond, and allowing citizens limited authority to intervene helps prevent suspects from escaping or causing further harm. However, because arrests interfere with personal liberty, the Constitution requires strict safeguards to prevent abuse. Citizens' arrest, therefore, represents a balance between 1, protecting society from crime, and 2, protecting individuals from arbitrary. Why can't I always pronounce this? From a very young age. So that means nilly-willy. You just detain a person because you are no. You just cannot do that. Simply because somebody behaves suspiciously when you're like, why do you behave that way? And then you conduct a citizen's arrest. That's not right. Now, here's the important part that I want to understand in my research.
But also the other areas around law enforcement agency. Law enforcement, the feedback we got, because Minister Lamula has been doing the engagement on the continent, and consistently feedback that we're getting is around law enforcement. But also we are seeing the deterioration of those who've been doing door-to-door. So we've been working around the clock to ensure within the communities we don't have people who are impersonating themselves. And I think I want to use this word because they must understand. If you go into a house, you go to a shop, you go to a factory, and you want people to produce documentation, you will be arrested, and the charge will be impersonation of a law enforcement agency. And they must go and look in the schedule how many years you'll go to prison for. Because people don't understand. Impersonating a law enforcement agency is a serious crime in this country. So we want people to stop it. Give us the details, we'll be able to deal with it.
So I wanted to know if the minister can refuse citizens to exercise Section 42 of the Criminal Procedure Act. And the research, well, went further down the rabbit hole. And it says, in general, no, the minister cannot refuse South Africans Section 42. The government cannot simply prohibit South Africans from exercising a statutory power that Parliament has created. I was shocked when I heard that. Provided citizens act within the law. I mean, Section 42 of the Criminal Procedure Act is an act of Parliament. Because Section 42 forms part of an act of Parliament, citizens remain entitled to rely on it whenever legal requirements are met. However, this does not mean the right is unlimited. Of course, I understand that in South Africa, Section 36 of the Constitution does kick in. This is the limitation clause. As a private citizen who is untrained by the police, I know my limits. And those limits are attributed to Section 36 of the Constitution. Again, guess who's supposed to be educating South Africans of this? The Minister of Justice and Constitutional Development. All right, the Constitution itself allows rights and statutory powers to be limited under certain circumstances. One, constitutional limitations. Under Section 36 of the Constitution, rights may be limited by a law of general application if the limitation is reasonable and justifiable in an open and democratic society. By saying that we are going to be charged with impersonating police officers, that's not limitation. That's overreach by the minister. She's supposed to educate us on limitation of Section 42, not create her own law, if you may, around Section 42. If Parliament amended the Criminal Procedure Act to narrow the circumstances for citizens' arrest, such amendments could be constitutionally valid if they satisfy Section 36. Of course, they do speak in my research about public safety, state of emergency, which I don't think it's something that I should read. Abuse of Section 42 is important. If individuals misuse Section 42 to assault, intimidate, unlawfully detain, or discriminate against others, government may prosecute those responsible. Such enforcement does not abolish the power of citizens' arrest. Rather, it ensures the provisions or the provision is exercised lawfully. I know, Guti, we march peacefully. We do things peacefully, but there will always be that's criminal, that takes advantage of the operation. And then when they are caught out, they say, no, I was exercising Section 42. You cannot be causing people pain. You can't. And you're not Home Affairs either. Okay, also important limitations of Section 42, very important. Section 42 should never be interpreted as permitting vigilantism, mob justice, torture or assault, punishment before trial, prolonged detention, so beyond 48 hours. I don't know what the exact reasonable time to detain a person. Unlawful search beyond what the law permits, like people's documentation. You're not allowed to do that. Once a suspect has been secured, the matter becomes the responsibility of the South African Police Service and the courts. All right, very important. All right, guys, please let's do that. So I wanted to know also about section 42, if it can be considered as impersonating a police officer, because that's what the minister said. Those that exercise section 42, well, she did not say those that exercise section 42, but you can tell that that's what she has in mind, because section 42 has been a thorn under her foot. So without her saying it out loud, you could tell that that's exactly what she's talking about. So I wanted to know in my research if section 42 is impersonating a police officer. And the answer was no. Simply exercising the powers granted by Section 42 of the Criminal Procedure Act 51 of 1977 does not amount to impersonating a police officer. The law itself gives private persons limited authority to make an arrest in certain circumstances. When a citizen acts within those legal limits, they are exercising a statutory power, not pretending to be a member of the South African Police Service. Yeah. And then, in conclusion, why a Section 42 arrest is not impersonation. A citizen making an arrest under Section 42 is not claiming to be a police officer. Instead, they are saying, in effect, I am arresting you as a private citizen under the authority given to me by the Criminal Procedure Act. So, a police officer will introduce themselves as a police officer. A private citizen that does citizen's arrest, they need to learn this sentence from what I'm saying. I am arresting you as a private citizen under the authority given to me by the Criminal Procedure Act, or Section 42. That authority comes directly from legislation enacted by Parliament. Therefore, the citizen is acting under a lawful power specifically granted to members of the public. So, unfortunately, the minister cannot come and say, I will arrest you for impersonation. She can't. When does it become impersonation? I agree. Wearing a South African police uniform, claiming to be a police officer, producing a fake police appointment certificate, ordering people to obey instructions solely because they claim to be police, and conducting searches or investigations while falsely claiming police authority. I agree. Arrest them. Those are criminals. Those are criminals. So, yeah, guys, it looks like that is that I wanted to understand about Section 42. And this is not supposed to be our responsibility as citizens. This is the responsibility of our government by ensuring that every school, every house, every government department. So, Mamuluku Kubai, this is what you should be distributing to every South African citizen. And then take the position to educate. You need to talk to us. That's how you speak to South Africans. And I feel like Section 42 needs to be taken to court for legal clarity, whether it's taken to the Constitutional Court or to a high court, because we cannot be having ministers that want to pretend Section 42 doesn't exist. We cannot do that. So we need to take it to court, test it there, and see if the minister can just throw around threats at citizens. Anyways, fellow South Africans, please, whatever you do, enjoy your day, and let's continue defending this country. And don't allow yourself to be spoken to like you're a child. Anyways, enjoy your day. Goodbye.